You are driving home. Red and blue lights flash behind you. You pull over. The officer approaches, and within 60 seconds you say something that turns a routine traffic stop into a full investigation, a search, an arrest. All because you didn't know 5 things that case law says you're legally allowed to do. This is educational content. For specific legal guidance, consult a licensed attorney in your jurisdiction. I've analyzed hundreds of traffic stop cases, reviewed Supreme Court rulings going back decades, and studied body cam footage from thousands of police encounters. Here's what I found. Most drivers lose their rights not because the law fails them, but because they don't know what the law actually lets them do. Every day, people hand over constitutional protections they were never required to give up. Number 5 might surprise you, but number 3 is the one almost nobody realizes is even legal. 5 legal moves. Exact words. Supreme Court backing, number 1 alone has gotten entire criminal cases thrown out. Let's go. Trick number 1 is the violation demand. Here's the mistake. When an officer approaches and asks, "Do you know why I stopped you?" Most drivers answer. Some guess. Some admit to speeding. Every one of those responses is legally dangerous. Under the Fourth Amendment, a traffic stop is a seizure that must be justified by a specific, articulable traffic violation the officer actually observed. That's rooted in Terry versus Ohio and applied in suppression hearings across the country. If the officer cannot articulate a specific violation, the stop itself may be unconstitutional, and everything found during it gets thrown out under the fruit of the poisonous tree doctrine from Wong Sun versus United States. Picture this. The officer says, "Do you know why I stopped you?" You say, "I might have been going a little fast." That statement just created probable cause on camera. No suppression motion works now. You provided the justification yourself. That opening question is trained behavior designed to get you talking before you think. The body cam has been rolling since the moment those lights activated. Wrong way. I think I was speeding. What you did, handed them the case. The exact words are, "Officer, what specific traffic violation did you observe?" Say it calmly and firmly. "Officer, what specific traffic violation did you observe?" If they push back, "I respect your authority." "Officer, what specific traffic violation did you observe?" 3 times if needed. It forces them to articulate legal justification on camera before anything else happens. If they cannot name a specific violation, that is the foundation of a suppression motion. If they can, you know exactly what you're dealing with without volunteering a word. Progressive escalation. If you answer instead, the officer now asks where you were going, about alcohol, what you have in the car. One answer opened the door to everything. Don't open that door. Bottom line, never answer, "Do you know why I stopped you?" Force them to name the violation on camera first. Forcing the officer to name the violation protects the legality of the stop. But everything happening during that stop is being recorded. By whose camera only? Under Glick versus Cuniff. You have a First Amendment right to make sure your own independent recording exists alongside the officer's. Fourth Amendment protection guards the stop's legality. First Amendment rights guarantee you the right to document the encounter yourself. Without it, you're relying entirely on the department's footage. That's trick number 2. Trick number 2 is the recording shield. Most people either secretly try to start recording, which looks furtive, or don't record at all. Both leave you exposed. In Glick versus Cuniff, the First Circuit Court of Appeals ruled unanimously that recording police officers carrying out their duties in public is a constitutionally protected First Amendment right. Multiple federal circuits have reached the same conclusion. Recording police in public is not obstruction. It is a constitutional exercise available to every private citizen. Picture this. You quietly try to start recording as the officer approaches. He notices. His energy shifts. He thinks you're hiding something. The stop that should have ended in 2 minutes is now escalating. Your nervous movements are captured on his body cam. The exact words are, "For everyone's safety, I'm recording this interaction as well." Say it out loud. Let the body cam pick it up. "For everyone's safety, I'm recording this interaction as well." If asked why, "Just for transparency, officer." Framing it as safety removes adversarial tone. You're documenting for both of you. Why this works: officers who know both cameras are running are less likely to engage in misconduct. Your recording is independent evidence that doesn't depend on the department's footage. If anyone interferes with your phone to stop the recording, that's a Section 1983 civil rights violation. Hold the phone in plain sight. Make no sudden movements. Bottom line: announce your recording out loud. Frame it as protection for both parties, and know your First Amendment right to record is federally protected. You've documented the stop. But what if there's a passenger? Almost nobody knows that under Brendlin versus California and United States versus Landeros, the legal rules for passengers are fundamentally different from drivers. Fourth Amendment protections cover everyone in the vehicle, but what an officer can lawfully demand from each occupant is entirely different. That gap is trick number 3. Trick number 3 is the passenger shield. Passengers constantly make this mistake. They answer the officer's questions, name, ID, everything, because refusing seems suspicious and they don't know the law protects them. In Brendlin versus California, the Supreme Court held unanimously that every occupant of a stopped vehicle is seized under the Fourth Amendment. But in United States versus Landeros, the Ninth Circuit ruled that demanding a passenger's ID is not part of the mission of a traffic stop. Quote, "The identity of a passenger will ordinarily have no relation to a driver's safe operation of a vehicle." Picture this. You're in the passenger seat. Stop is for a broken taillight. Officer asks for your ID. You hand it over. It comes back with an outstanding warrant from a forgotten fine. Now you're arrested. The body cam captured you voluntarily reaching for your wallet. Wrong way. Sure, here you go. Right way. The exact words are, "I'm not the subject of this stop. I decline to provide ID. Am I personally suspected of a crime?" Calmly. "I'm not the subject of this stop. I decline to provide ID. Am I personally suspected of a crime?" If they say yes, "Officer, what specific crime am I suspected of?" Forces articulation of an independent legal basis. Important: drivers must provide license, registration, and insurance in all states. This is passenger specific. In stop and identify states, Texas, Nevada, Arizona, Georgia, and others, you may need to verbally state your name if police have independent reasonable suspicion directed at you specifically. California has no stop and identify statute. Cooperation does not mean conversation. Stay calm, stay polite, but stay firm. Bottom line, passengers have no legal obligation to produce ID unless independently suspected of a crime. You protected the stop's foundation, documented the encounter, shielded passenger rights. Now the device every officer wants to access, and that 9 Supreme Court justices unanimously protected. Your Fourth Amendment rights cover the stop. Your right to silence covers your words, but neither protects your phone on its own. That required a dedicated ruling, the most unambiguous constitutional protection in this entire video. That's trick number 4. Trick number 4 is the phone wall. Here's the mistake. When an officer says, "Mind if I look at your phone?" people hand it over because it sounds cooperative and because they don't know about 2014. In Riley versus California, Chief Justice Roberts wrote for a unanimous Supreme Court, 9 justices, 0 dissents, that police must obtain a warrant before searching the digital contents of a cell phone, even incident to a lawful arrest. A cell phone carries what the court called the privacies of life. Quote, "Our answer to what police must do before searching a cell phone is simple: get a warrant." Picture this. Stopped for a broken taillight. Officer asks to see your phone. You hand it over. Location history, messages, financial apps, photos. The officer doesn't see one thing. He sees your entire life. The body cam captured you handing it over voluntarily. You waived the protection. Wrong way. Sure, what do you need? Right way? The exact words are, "I do not consent to a search of my phone. You need a warrant." Clearly. "I do not consent to a search of my phone. You need a warrant." If they push back, "I do not consent to a search of my phone. You need a warrant." 3 times. Unambiguous invocation. Why this works. Riley is binding on every court in this country. A warrantless phone search is unconstitutional. Everything found gets suppressed. But only if you said no. Consent waives the warrant requirement entirely. Officers can legally lie about evidence and witnesses. The one limit courts recognize is they cannot create fake documents. Everything else is permissible deception. Never answer questions without an attorney. Bottom line, your phone requires a warrant. 9 justices ruled unanimously. Say the words. Don't hand it over. Your phone is protected. But what about every other item in your car? Under Arizona versus Hicks, a ruling almost nobody knows about, physically moving an object to examine it is a Fourth Amendment search requiring probable cause. One of the most common officer requests during a traffic stop, "Can you move that bag?" becomes a constitutional violation if you don't consent. That's trick number 5. Trick number 5 is the item freeze. Here's the mistake. The officer sees a bag on your seat and says, "Can you open that for me?" And you do. In Arizona versus Hicks, Justice Scalia wrote for the Supreme Court that physically moving an object to examine it is a search under the Fourth Amendment. Officers had moved stereo equipment just inches to check a serial number. Even that small movement required probable cause. Not suspicion, not curiosity. That ruling applies directly to your vehicle. Picture this. Officer sees your backpack, says, "What's in there?" You say, "Just gym clothes, go ahead." He unzips it. Inside is something a friend left months ago. The body cam captured, "Go ahead." Consent obtained. Search is legal. Everything found is admissible. Wrong way. Sure, go ahead. The exact words are, "I do not consent to searching or moving any items in my vehicle." Calmly. "I do not consent to searching or moving any items in my vehicle." If they focus on one item, "I do not consent to searching or moving any items in my vehicle." If they say they just want to move it, "Officer, moving that item is a search under Arizona versus Hicks. I do not consent." Progressive escalation. They move the bag, find something small. Now have probable cause for a full vehicle search under the automobile exception. Glove box, trunk, everything. All triggered by one bag you let them touch. If they're asking permission, they don't have probable cause yet. Don't give them what the law requires them to earn. Bottom line, you are never required to touch, move, or open any item in your vehicle. Refuse consent clearly and calmly. Before these 5 tricks can protect you, you need the first 30 seconds handled right. Pull over using your turn signal. Turn on your dome light if it's dark. Turn off the engine. Hands on the steering wheel, visible. Lock your doors. Roll your window down no more than 2 to 4 inches, announce, "I'm locking the vehicle and will pass documents through the window." A fully open window lets the officer claim plain view of anything inside. 2 to 4 inches prevents that. Locking the doors makes consensual entry legally impossible without your explicit permission. Now, the most important principle running through all 5 tricks, your emotional tone. Everything we covered falls apart if you say the right words with the wrong attitude. Stay calm, stay polite, but stay firm. Asserting rights with an attitude escalates the stop and gives officers something to work with. Calm and respectful while exercising rights is what holds up in court. Do not be sarcastic. Do not match an aggressive officer's energy. Do not raise your voice. Do not argue at the roadside. Be respectful, not talkative. Cooperation does not mean conversation. The side of the road is not where you win. The courtroom is where you win. Stay calm. Request versus order. When asked to do something, ask, "Officer, are you asking me or ordering me to do that?" If asking, you can decline. If ordering, comply, but say, "For the record, what is the lawful reason? I am complying under protest, and my hands will stay visible." That statement is on camera and creates a record of non-voluntary compliance. Here are the 4 phrases every driver needs memorized before they get behind the wheel. Phrase 1, "Am I free to leave?" Under United States versus Mendenhall, a seizure occurs when a reasonable person would not feel free to leave. This forces the officer to either end the stop or declare a formal detention, both documented on camera. Ask it whenever the purpose of the stop seems to have concluded. Phrase 2, "I invoke my right to remain silent." Under Salinas versus Texas from 2013, silence alone is not enough. The Supreme Court ruled you must explicitly invoke the Fifth Amendment. Say the words. Don't just stop talking. Explicit verbal invocation is required. Otherwise, silence can be used against you in court. Phrase 3, "I want an attorney," ends all interrogation immediately. You can invoke this before arrest, during a traffic stop, at any point. Once said, any statements made without an attorney present are inadmissible. Say it and stop answering questions. Phrase 4, "I do not consent to searches." Clear, unambiguous, on camera. I do not consent to searches. Whether they're asking about your car, your phone, your bags, or your person, every single time, out loud. State variations. In Texas and Ohio, the smell of marijuana can still provide probable cause for a vehicle search. In Colorado and Maryland, odor alone is no longer sufficient. Stop and identify states. Texas, Nevada, Arizona, Georgia, and roughly 24 others may require you to verbally state your name if lawfully detained with reasonable suspicion directed specifically at you. California has no stop and identify statute. The federal constitutional baseline applies everywhere. State variations are exactly why consulting a licensed attorney in your jurisdiction matters. Here is the core principle of everything we covered. A traffic stop is a legal encounter with defined constitutional rules. Those rules protect you. They bind the officer. Courts enforce them every single day. But only if you know them and use them calmly and respectfully. The 5 tricks. Officer, what specific traffic violation did you observe? For everyone's safety, I'm recording this interaction as well. I'm not the subject of this stop. I decline to provide ID. Am I personally suspected of a crime? I do not consent to a search of my phone. You need a warrant. I do not consent to searching or moving any items in my vehicle. The 4 phrases, am I free to leave? I invoke my right to remain silent. I want an attorney. I do not consent to searches. Print them. Practice them. Have them ready before you ever need them. The time to learn this is not when the lights are already flashing behind you. This is educational content only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. You just learned 5 constitutional moves and the case law behind each one. But there are other critical moments in a police encounter where completely different legal standards apply. Moments before the stop, during post-stop questioning, at the station. People exercise their rights perfectly during a traffic stop and give them up in the follow-up encounter. I break down those other phases and the complete constitutional framework in the next video. It's right here on screen. Watch it before you face this situation. Let me know in the comments where you're watching from and what time it is right now. And remember, the Constitution doesn't protect you automatically. It protects you when you know it and use it. Know your rights.